are going to take your case. It depends on your residence or maybe where the seat of the corporation is. What's the law in my circuit? Is it binding precedents, which is good for me, or is it just persuasive? So you need to consider that factor. Another thing, I'll tell you a little bit about the United States. Our government is set up into so we have the president, that's Obama, okay? Under Obama is the Department of Treasury and the Department of Justice. Treasury is IRS, Internal Revenue. Justice, they're the lawyers for the government. Okay, so your case gets in federal courts, federal district court, you're going to be in the Department of Justice. The United States Tax Court, you use Treasury lawyers. They're different. The lawyers are different. The Treasury lawyers are more sophisticated in tax law. Sometimes that's very good, because if you want someone to understand some complex tax issue, maybe your opponent, if he's a smart tax lawyer, he'll appreciate it. He'll appreciate the unique point you're making. If you get a regular U.S. tax attorney, one day he could be doing a case about criminal law, and then the next day they might assign him over to the tax section. So you might get someone unsophisticated. In some cases, that might be what you want. Maybe I don't want anybody who knows that much about the tax law. So all of these issues that you're thinking about, the cost, what's the issue? Is it a real issue? What's the cost going to be? How long is it going to take? How does that influence my client? The complexity of the case. What's the law in my circuit? All of that it goes into your thought process in selecting a court. One other thing you need to know, the United States government typically wins 95% of the cases that go to trial. 95% for the bad guys, 5% for the good guys. I think that's anybody have an idea why that is?
They're 100% sure they're going to win, and they take the cases that they're sure about.
You're absolutely correct. The United States government will not try a case if it thinks it's going to lose. Let me say that again. They don't want to try a case they think they're going to lose. They'll settle it. They only want the cases they know they're going to win. Why do they lose 5% of the time? And we're happy to report we were in the 5% at one time. Yeah,
once every 10 years.
Once every 10 years, will we get in that 5%? Because sometimes the IRS wants precedence. Sometimes the government has an issue that is unsettled, and they want a case that they can rely on that says this is the law in the area. Most of you are accounting students. How many accounting students here? Okay, good. So you understand the concept of amortization? Yes? Okay. And this is a case that we tried goes back into the beginning of our firm in the late 1980s, 30 years ago.
He got the girl, I got the fee.
You'll find out how that works.
This is true.
It's a true story. I have a client who bought a business, and the business had a customer list. Customer list. Customer list was assigned a big value. In this particular case, it was well over $1 million, several $1 million, to the customer list. In the contract, the buyer, my client, also got a covenant, an agreement, promise not to compete. So I buy the customers from you, and I pay you for the customers, and you also promise that you will not go back into business, you will not compete with me for 5 years. My client's accountant took the customer list and he wrote it off, amortized it over 5 years. So he was taking his investment and he was taking a deduction from his income tax. Does that make sense to you? Yes? Okay, good. The government came in and they said, well, no, we don't think you can do that. We don't think you can do that because the only way that you can amortize an asset is if you meet a two-part test. 2 parts. First, you've got to be able to set a value. A value. How do you value a customer list? How do you do it? The second, it's not like valuing something like this where we know in 5 years maybe or 10 years it won't be useful, but a customer list, it's intangible. It's not real. Second test is, I said you had to get the value. It has to have a determinable, useful life. You've got to be able to figure it out. How do you figure out the life of a customer list? It's, you know, how do you do that? Oh, no, by the way, you have to have that information when you buy the asset. It isn't like you can buy the customer list and then see how it depreciates or amortizes over time in the future. Under US law, you had to know that when you bought it. IRS says, in a customer list, you can't figure out the value, and even if you could figure, even if 2 people can say, wait a second, you're selling, I'm buying, we can agree on a value, that should set the value. How do you determine the life? And you have to know the life before you buy the list. We tried that case. That was a refund case. We weren't going to go to the United States Tax Court. We wanted to go to the Justice Department. Because we were looking for a judge who was going to be, in our mind, a little more sophisticated about factors other than just tax law. We tried it in Justice Court. Do you think we used a jury? Anybody?
No.
Any reason why?
They couldn't know answers.
Well, it was a complex case, right? You're accountants, you understand it. That's an issue. And secondly, you know, I've got a guy sitting in a witness box who bought a business for some millions of dollars. People sitting in the jury box, you know, we didn't think that they were going to, well, you have a lot of money, what difference does it make? You know, sometimes you get hit with that kind of attitude. Does that make any sense to you? That we wanted a judge, we wanted someone who was just going to look at the law. We weren't interested in, who said emotion? You said emotion. This was not a case where we wanted emotion. What we wanted was a scientist. Without getting into all of the details, we used some scientific technique, engineering techniques. We hired an expert. A guy that, believe it or not, I had met at Deloitte. I think I mentioned I worked at Deloitte. Deloitte had a department, that's all these people did. They were engineers and CPAs. They valued all kinds of assets, anything you can imagine. Air rights. You know what air rights are? Yeah, right? Air rights, they valued them. So we put in the report, and the footnote of the story was, we thought there was enough law to settle the case, because it was a big risk for my client. And I tried very hard to settle the case. The government wouldn't talk to me about settlement. The judge couldn't believe it. Settle the case. No, they wanted precedence. They gave as a matter of fact, the United States Attorney at the time, you may know this name, was Rudy Giuliani. Did anybody hear that name before? No? He was the United States Attorney, pretty famous guy. He became mayor of New York after he left the U.S. Attorney's Office. We won the case at trial, one of the 5%. The government appealed. We won the case on appeal. In 1990, the Internal Revenue Code was amended. It was changed. All intangible assets in the United States are amortizable over 15 years. That's it. Issue solved. No more worried about determining life. No more worried about value. You just depreciate it. Unfortunately, that's not a good result for taxpayers because 15 years is a long time to write off your asset. But that was the result, 15 years straight away. Now, the footnote, the epilogue to the story. The guy that I represented was very happy with the result. About 6 months later, he introduced me to his daughter, my wife today. I got the girl, he got the fee. That's a true story.
True fees
And what is
never
the outcome
die.
of this case?
What was the result?
Yes.
The IRS agreed that the asset, we could determine a value, because we argued the best indication of value. There's a lot of ways to value assets, but there's nothing better than when two parties, independent parties, arm's length parties, unrelated parties, one who wants to get as much money as possible for the sale of the asset, one who wants to pay as little as possible. That's what we call Tajik bargaining. The idea right? You know, we want to pay as little as possible and get as much as possible, that kind of thing. Okay, when two independent parties agree, that, we said, is the most pure, accurate, fair form of valuation. You don't need appraisers, you don't need accountants. When two people are at conflict and they agree on a value, we said yes. And we used these advanced valuation techniques from the engineers who took, if you're interested in this, what we did is we looked at our client's customer list for the 5 years previous to the sale. And we saw, okay, so let's just say in 1975, we'll just pick a year. This was my customer list. And what did the customer list look like in 1980? And using that data, we had the data. The data was key. We developed a formula that said that's the value of the life of a customer list. Now, there was one other case that was very important to us. I'll mention it quickly. There was a case that said, and if you have some data that says what the life of the asset is when you purchase it, like we developed, you can then introduce into trial what really happened, what happened in the future. So we then showed the court, that case started in, you weren't born, that case started in 1978. We tried it in 1987. It's 9 years before we got in front of a judge. 9 years. But we had all this data to show the judge, hey look, we looked at the 5 years previous and it looked like the life was this, and guess what? When we went forward, it was pretty close. And we win the case. And that was the result. So they said, okay, yes, you can determine it, you can figure the value, and it had a determinable useful life. I didn't mean to get into all the detail on the case, but the idea was sometimes that when you take a case, before you decide to take a case or get involved with a case, sometimes you'll be consultants on a case. You just don't take money from your client. You're there to win. You're there to win. You're not, it's how we make our living. That's true. But we make our living by winning. That doesn't mean you're going to win every time. But you better make sure you have a case and an argument. Because if the government says, we're going to try the case, they believe in here and in here that they're going to win it. One other little thing that we have in our tax law, which is just one other thing to and again, it isn't important that you remember the specific issue, but it's the notion that when you're thinking about being involved in a case, all these things you need to think about and to assess and to evaluate and determining whether you should pursue it. We have a concept under our law called equitable recoupment. Equitable recoupment. What does that mean? Do you remember we had a conversation about the statute of limitations? Under our law, after 3 years, the government cannot, there's exceptions, always exceptions, but 3 years they can't go back and get money from you. But this is one little bullet the government has in its pocket. So, I'm going to draw a little picture. This is 3 years, okay? So you, and then this is, okay. You start a lawsuit on this year, okay? It takes you several years to get resolved. You win the lawsuit. You win the lawsuit, you're going to get your refund, or you're not going to pay. If you bring the lawsuit, the government gets to look back. It opens up the closed years. And if they can find a liability in the closed year, think how unfair that is. But if they can find a liability in the closed year, they can offset your winning in this year. Now, let me explain to you what is a bad day for a lawyer. Because there's good days and there's bad days. And a bad day is, I have very good news for you, we won the case. The bad news is you owe a lot more money than when we started the case. So that's a bad day, and that can happen under this concept. The reason I mention it is not to remember it precisely, but always know the risks of litigation, and they are so severe. One other thing, we were talking about tax cases. So you got the schematic, I think it's right at the end of this. Scroll. Okay, here you go. All right. So, United States Tax Court, District Court. So this is a court. You don't pay. Here you pay and file for a refund. Here you pay and file for a refund. The law that's applicable to them can vary. You appeal if you lose here, or if the government loses. You go to your Court of Appeals in your circuit. That's just determined geographically. The Court of Federal Claims is a special court. They have their own appeal, Court of Appeals. And then ultimately, if you can see it, it's the United States Supreme Court. It's our highest court in the land. The United States Supreme Court takes very, very few tax cases. Very few. They hate them. Typically, the case they will take was the example I was mentioning. If the law in California on an issue is completely different than the law in New York, conflict in the districts, then the Supreme Court might step in and take the case and settle it, because the Supreme Court is the highest authority and you have to follow the precedents of the Supreme Court. You have the concept, of course, bankruptcy in Kazakhstan.
Yeah.
Okay, does it operate like the U.S. where if I'm insolvent and I'm in a lot of trouble financially, I file for bankruptcy. In the United States, all collection stops. I don't know, does it work like that here?
No.
What happens in, or is that how it works? Yeah, if you file for bankruptcy, your debtors cannot, you're now in bankruptcy court. What's going to happen? The court assumes responsibility for all of your assets, it gathers your assets, liquidates them, turns them into cash, pays off however much they can, and the debtor walks away, with exceptions, always exceptions, without any debt. The United States Bankruptcy Court, it's a special court. It's an Article I court, it's a special court. It can even hear tax cases, although I have never. They have the jurisdiction, but they can hear it. So there are some special courts. Okay, we talked about cases, we talked about some of the issues. Now I'll leave you with courts and trials with the single most important issue that you have to consider. If you take nothing away from anything I say tonight about trials, this is the golden nugget. Make sure the lawyer gets paid, okay? That's the key. Lawyers always have to get paid. I'm only teasing. But we would not take a case, our office would not take a case without getting paid up front. It's very common in the United States. You don't, because why is that? Well, for two reasons. You don't want to work and not get paid, of course. But there's another reason. Once you're in court, once you appear, you cannot get out of the case automatically. So imagine, somebody hires you to take a case and you don't get your money, and you put your petition in, and they're not paying you, and you're working. And then you go to the court and say, you know, Judge, I'm not getting paid. I'd like to get out of the case. The judge can leave you in it. And you have to work just as hard as if you were getting paid. Because in our system, once you appear, you're in, whether you like it or not. And particularly in federal district court, making an application to get out of the court is very, very difficult. You have to find another lawyer to succeed you, very, very difficult. Now think about it. If you've got a client who's not paying you, how easy is it for you to go find another lawyer to take your position? It's not going to be easy. Just another little issue on that. Now, unless there's any questions in this area, okay. Do you want to take a 5-minute break?
Someone was talking about a breakdown.
Yep. 5 minutes, 10 minutes, and we'll talk a little bit about it. Thank you. The client has to accept. He was thinking the judge has to approve the reassignment.
Are you making video of this? Yeah. This is terrific. It'll be digital? I've never heard much about this. He's good. He's a real professor. He's good.
He can continue.
Yeah.
When he finishes.
He looks like lawyer in the process.
Have an issue.